Once more, welcome to our video series that looks at criminal liability in terms of South African law. So this is just one of those videos. This one looks specifically at unlawfulness as a basis for criminal liability in South Africa. Please look out for the other videos that deal with the different aspects so that you can have a full appreciation and a full overview of the whole spectrum of what we have discussed in this series. I hope you find that this video is useful. Just to set the ball rolling, let's look at the focus of today's video. By the end of this video, you should be able to identify instances in which unlawfulness is excluded in law, distinguish between unlawfulness and culpability, because a lot of people seem to confuse these two. Then identify policy considerations and the grounds of justification that exclude unlawfulness, and explain the various grounds of justification. Last but not least, you should be able to explain the basis for these justificatory grounds. So this and other issues shall be discussed as we proceed. In our other videos, which are part of this criminal liability in South Africa series, we've looked at the voluntary human act or conduct as a key element of criminal liability, and then we've said that that conduct must conform to definitional elements of a crime, including causation for result-oriented crimes. And then this particular one is looking at unlawfulness, where we look at the justificatory grounds and other considerations. And then our other video is on culpability. It's different from this one. So all in all, in this series, we have 4: voluntary human act or conduct, definitional elements including causation, then unlawfulness, this particular one, and then culpability, another one. So pay attention to this, because the one on culpability builds upon this one, as you shall see when you have access to that one. Now, looking deeply at unlawfulness, this is what we get. Unlawfulness in criminal law. You find that definitional elements of a crime do not usually spell out the requirements of unlawfulness and culpability. So you can read a statute and it may actually cite a certain act as a criminal act, but it may not state the requirements of unlawfulness and culpability. So that's why some people have described those as unwritten or invisible requirements of the crime, because whilst they are so important and essential to our understanding of culpability, rather liability in respect of that crime, they remain unwritten in the statutes, so they remain silent in that case. But a jurist, a prosecutor, or a defense lawyer must be aware of that, or a judge. Of course, those are the people that work in the prosecutor, the defense lawyer, and the judge or the magistrate. They must always take cognizance of these unwritten or the invisible requirements of the crime. So we are saying that the mere fact that an act conforms to definitional elements and which has been committed, that is, doesn't mean that it is unlawful. As you shall see, look at the examples that we have here, which appear unlawful at face value, but they are not. For instance, murder is defined as unlawful and intentional killing of another human being. And then sometimes you find there's a killing of another human being or person justified on the grounds of self-defense. Look at another instance. Inserting a knife into the body of another human being is a violation of their bodily integrity. But it can be justified on the grounds of necessity, as when a doctor operates on a patient. So the doctor actually inserts a knife in the body of a human being. He is not accused of assault or assault with the intent to cause grievous bodily harm. But if another person who's not a doctor does that, they will actually be prosecuted for it. How about driving beyond the speed limit? It can be justifiable on the grounds of necessity. The case of Pretorius 1975, recorded in South Africa, but held by in fact, it was held before the court in Southwest Africa. You find that driving beyond the speed limit was actually justified on those grounds, as grounds of necessity. What you find is that there is provisional unlawfulness of every act that conforms to definitional elements of a crime. So we are saying an act which meets the requirements of a crime according to the definitional elements is provisionally unlawful. For instance, when one person causes the death of another person, that is on the face of it unlawful, unless there is a presentation of grounds that justify such a termination of the life of another person. But we are saying mere compliance of an act with definitional elements of a crime does not mean that it is unlawful. As we have already alluded to, if there are grounds to justify it, then it might seem provisionally unlawful at face value, but at close scrutiny and inspection, you find that it is not that unlawful. So unlawfulness is excluded when provisionally unlawful action is cured by the presence of grounds of justification, or is justified in terms of the legal convictions of the society, or the morals, the good morals, the bony morals of society. With what we call grounds of justification, and we also got what are called legal convictions of society. These are actually the grounds that would render a putatively unjustified or unlawful act into something lawful. Grounds of justification are reasons accepted in the interest of society to justify an otherwise unlawful act. We have examples of self-defense or private defense for murder. We have necessity in cases involving relative compulsion. Remember, we spoke about relative compulsion and absolute compulsion when we spoke about an act or voluntary human act. So you find that it may be necessary sometimes. If a necessity may actually justify an act which is at face value unlawful. And then there's consent, whereby one person consents to injury being inflicted by another. We've got other considerations such as official duty. We will look at some of these as we go down in the discussion. So we also have got what are called legal convictions of society, whereby we are looking at the bony morals or the good morals of society. You find that conduct is unlawful if it conflicts with the legal convictions of a society. So each society has its own legal convictions, and what is permissible in one society is not necessarily permissible in another. So when you look at the legal convictions of society, you must take into account that it tends to be contextual. The law endeavors to strike a balance between the interests of society and the interests of individuals. Hence, you find there's an exclusion of unlawfulness in acts that appear unlawful at face value. Uh, because there is an interest in the protection of life, property, dignity, and many other interests. It may be upheld. They may be upheld to exclude unlawfulness in acts that are provisionally unlawful. In other words, private defense may then be invoked to protect life which is under threat, or to protect property, or to protect human dignity, and so on. So the bottom line is that conduct which is provisionally unlawful, if it does not conflict, if it doesn't conflict with the body morals of society, it may actually be justified. So the grounds of justification are mere practical aids in the determination of unlawfulness, which exclude unlawfulness in common instances. So we are going to be looking at grounds of justification which are actually invoked to exclude unlawfulness. But as we have just said, this is for practical reasons, to protect the interests, to balance the interests of the individual with those of the society. So on that note, you find that some of the practical applications of the grounds of grounds excluding lawfulness are as follows. Take the case of S versus I in 1976, whereby you find that this case illustrates the application of grounds which exclude unlawfulness. The story went along these lines. Z, a married woman, hired X, a private detective, to track Z's husband Y, who was suspected of marital infidelity or cheating. So Z wanted to gather evidence of infidelity so that she could use it in the anticipated divorce proceedings. Now, X then went on to spy through a window of a building wherein Y and her lover were enjoying their intimate moments, and then later on criminal charges were pressed against X based on crimen injuria, and then X pleaded that spying was justified in the interest of society to prevent adultery. So after deliberations, the court accepted the submission that the act was justified to uphold the contemporary body morals of society. Now, as we have said, that was in 1976. I'm just curious to ask and find out if such a conduct would still be justified in South Africa's current constitutional dispensation. For instance, when you think about Section 14, which talks about the right to privacy, would this S versus I argument on spying into the privacy of people, would it still be justified in the light of the desire to protect the privacy of individuals? But as we have said, the body morals of society is not a constant standard as such, but it is very dynamic. So what may have been accepted in 1976 may no longer be accepted now. For instance, then it was necessary to uphold high moral standards and punish adultery and all forms of indecency by all means. But you may find out that now in the current dispensation, the right to privacy has actually trumped up this need for the protection of high moral standards. So while somebody may want to, may have wanted to prevent infidelity, I wonder if it would still be justified now. Otherwise, X could now be convicted for this crime in injuria, which I escaped in 1976. On the note of distinguishing between unlawfulness from culpability, it is very essential to understand that sometimes people conflate these two. In the process of discussing unlawfulness, people end up bringing in elements of culpability. It's just because sometimes this distinction doesn't come out as lucidly as people would expect it to be. But if we could just attempt a distinction, we would say that unlawfulness and culpability are distinct from each other. Of course, culpability is covered in another video all by itself. But the subject, or rather the subjective state of the mind of the accused, is actually irrelevant in the determination of unlawfulness. So unlawfulness is based on grounds of justification and the boni mores, or the policy considerations of the broader society. Hence, we are saying it doesn't matter the state of mind of the accused. That is the subjective state of the mind, whether it was actually intentional or negligent. That's not what we are talking about at the moment, but we are looking at whether it is justifiable on the basis of the grounds. One of the grounds, of course, taking into account and accepting the fact that there is no complete list of those grounds, but we have those common and prevalent grounds. And so unlawfulness concerns this justifiability of an act which meets the definitional elements of a crime, while culpability concerns the mental element of the person committing a provisionally unlawful act. So we are saying that culpability is about the mental state. That is whether the person acted negligently or intentionally in the commission of the act, what is called mens rea. So unlawfulness does not concern itself with the mental state of the accused person or the perpetrator of an act, but unlawfulness is concerned with whether the conduct itself may be justifiable in law, as maybe falling within the parameters of some interests that are protectable rather for the interest of the whole community. So if you find that maybe conduct was carried out in self-defense and the interest being defended actually was deserving of such protection, then under such circumstances we would say that unlawfulness is excluded, without really thinking or looking into whether it was done intentionally or it was done negligently. So culpability is the one that deals with the state of the mind, which, as I have already said, is the subject of another discussion in another video. Just look out for that one so that you may be able to get the full picture of what we are talking about. So, as I have already alluded to, we've got quite a number of grounds of justification in criminal law. Some also apply to delicts. When you look at the law of delict or tort, these are some of the things that you will be talking about. We have got what is called private defense, but in colloquial terms, people often talk about it as self-defense. And then we have necessity, we have consent, then we have spontaneous urgency or negotiarum gestio, and then we have the right of chastisement, which is no longer part of South African law, of course, and we'll discuss it as we proceed down in the course of this video. Then there is obedience to orders and official capacity. These are some of the common grounds of justification that we encounter in terms of South African criminal law. Now, let's look at private defense. As I have already alluded to, colloquially it's called self-defense. And we are saying that a person acts in self-defense when he or she undertakes conduct, which then becomes lawful. So personal defense occurs if he or she uses force to repel an unlawful attack. So it's an unlawful attack that is being repelled. In other words, one cannot invoke the right or the self-defense in order to protect, to actually resist, say, lawful attack. Like if a police officer wants to arrest you and then you give a punch, you throw her down and then you try to escape. If one does that, then it is not acting in law or in lawful. It's not a justifiable ground of justification to attack a police officer who's effecting a lawful lawful arrest. So we are saying personal defense is only qualifies to be personal defense if one is warding off or averting an unlawful attack by, say, an assailant or a criminal. And the requirement is that the attack must have already commenced. In other words, you cannot, just because you anticipate that somebody is going to attack you, then you take a weapon and attack them preemptively. If you do that, then you'll be guilty of an offense. So it is to avert an unlawful attack which has already commenced or immediately threatens to commence. In other words, if it's within the spare of the moment, somebody maybe is drawing a weapon with the intention to cause harm, and then you manage to kick away that weapon and overpower the person and maybe end up killing them in the process. We are saying that threat was actually immediate and threatening. But it can't then be an issue where somebody threatened you yesterday or last week, and then you meet them today and you then attack them, claim that is in private, it is in personal defense, private defense. It's no longer in private defense. You're just being plain, you are the one who's now being the assailant. And then we are saying, so it's an attack, an unlawful attack which has already commenced or immediately threatens somebody's life. So you can act in private defense to protect somebody's life, bodily integrity, or you can protect property or other interests protected by law. So this defensive action must be necessary to protect those interests being threatened. And it's very essential to take note that the private defense must be directed towards the person carrying out the attack. In other words, if Mr. X is attacking you, and then you take maybe a weapon to attack them in order to prevent the perpetuation of the harm, you can't then go on to attack Y, who is not the perpetrator. So the private defense efforts must be properly directed to the person carrying out the attack. And then the force employed in defense should not be more harmful than is necessary. For instance, if somebody, say somebody decides to give you a slap with an open hand, an open palm of the hand, you can't then go look for an AK-47 and gun them down. We are saying there should be proportionality between the extent of the harm and then the reaction itself. So it must only be necessary to prevent harm being threatened. And The defender, that the person undertaking this private defense, must be aware that she's acting in private defense. You can't then maybe somebody is attacking you and you think maybe you are not even aware that there's an attack, and then you attack the person, even if it turns out that the person was planning to attack you. If you were not aware that it was necessary for you to defend yourself, then this ground of justification doesn't operate in your favor. Now, there is another ground called necessity. Somebody says it's making a choice between two evils. So necessity can best be expressed as making a choice between two evils. You have a person who acts out of necessity, and that their conduct is lawful. If she acts to protect life, property, physical integrity, or other legally recognized interest, the interest being protected must be endangered by a threat which has already commenced or is about to commence. So remember what we said in respect of private defense. It also applies here. The threat must, the danger must actually have or commenced or is about to commence, and there must not be an alternative way to avert the danger. In other words, the step or the approach taken, the method adopted to stop the harm must be the only one available. If there is an easier way, for instance, if somebody threatens to assault you and there is a way to run away, then you should. But if you are cornered and there's just no way for you to escape, and then you end up maybe killing the person in the process, then it's a different story. So we are saying necessity is only applicable in the absence of alternative ways to avert the danger, provided that the person facing the danger is not legally required to endure the danger. People working in capacities such as the police, the security personnel, or the military, or firefighters. If you are a firefighter and then the building is on fire, you are, by virtue of your job and commitment and undertaking, it is expected for you to endure the dangers posed by the fire during a firefighting operation. And then we are saying the interest being defended through the necessary reaction must be proportionate to the interest being threatened by the danger. We have already highlighted that in the other slide on where we spoke about private defense. Now, imagine we have what we call relative compulsion. In the S versus Goliath case of 1972, you find that one person, let's call them X, had actually, held Y and ordered Y to kill Z. So under such circumstances, the killing of Z by Y was actually justified as a necessary reaction, because in any case, rather the killing of Z, if Y had not killed Z, then Y would have been killed by X. But this kind of defense is not taken very easily. Courts are very, very skeptical when it comes to accepting this kind of defense, because as we have already said, it's making a choice between two devils. So to say that one should kill another person on the basis of relative compulsion is actually not it's not a defense that one can easily invoke and expect to be believed. So we want to distinguish between necessity and private defense, and this is how we look at it. Their origins are different, and their objects are also different. In terms of their origin, you find that private defense is from human attack, but necessity is averting danger from a human attack or from a natural occurrence. It might be a fire, it might be a hurricane, and so on. So you don't defend yourself from a storm or a hurricane, but you defend yourself from human attacks. You don't defend yourself from an attack by a lion or by a dog. So in other words, if you kill your neighbor's dog, it's not because you did it in self-defense, but it was out of necessity, because there was a choice between either being killed by the dog or killing the dog yourself. So we then talk about necessity. Or think of the occurrence of a fire, where because the fire that has broken out, and then you happen to be inside a building, and you use whatever lever you find available to break the doors, to find a way, an exit out. You can then not be charged, even if you are charged with malicious injury to property. You can then, invoke the defense of necessity to say, I had to destroy, I had to break open the doors so that I could escape the danger that was pending. And then the object or the intention of private defense, you find that it's directed towards a human attack, but necessity is directed against the interests of another innocent party. For instance, if you are in a building which catches fire and then you break the doors open, it is not, you are not causing injury to a person, but you are causing injury to the property of that person. They may not have caused the fire, but because you have to escape, they suffer the damage. Or sometimes, it leads just necessity just leads to the violation of a legal provision. Remember, we spoke about the case of Pistorius, who had to drive beyond the speed limits just to take a child to hospital who needed emergency medical attention. So under such circumstances, it was only a violation of this statute, which is what you call this, a legal provision on the speed limit. So one of the questions we always want to ask ourselves is, does necessity justify the killing of another person? Remember, we spoke about the story of the case of S versus Goliath. It's always very controversial to say whether it justifies the killing of another person. Another ground of defense is consent. When a person consents to harm inflicted by another, the act is not unlawful. Consent is expressed in the Latin maxim volenti non fit in iuria, and there are cases in which consent is an aspect of the definitional elements. For instance, the crime of rape as sexual intercourse without consent. So if an accused proves that there was consent, then he is entitled to an acquittal, because consent is actually an element of one of the elements within the definitional elements, which means where there is consent, then the crime itself is, in fact, the unlawfulness is extinguished. Then there is the issue of consent being insufficient in certain cases. For instance, we are saying consent doesn't exclude unlawfulness. When one has, in relations with a minor, sexual relations with a minor below the age of 12 or below the age of 16, that is not legitimized by the presence of consent. So you find that even if one were to argue that there was consent, the issue is it would not be appropriate, it would not persuade a court of law. So because consent excludes unlawfulness if the injury they cause is not contrary to public policy. You find then that where public policy condones a particular act, then consent under such circumstances would then be accepted as a valid ground of justification. So there are circumstances for valid consent, because taking into account that consent is not sufficient to always exclude unlawfulness. There are circumstances in which consent is not valid. For instance, look at homicide or murder. Consent to be killed does not confer lawfulness to the act. The act remains unlawful, even if the person killed is actually volunteered and consented to it. In South Africa, euthanasia or mercy killing is illegal. This was decided in 1970 in the case of John, as well as in 1940 in Favorite. You find that when a person consents to being killed, it is contrary to the good morals of society. So one who assists another, like in the case of John, a husband had offered, in fact, given a revolver to his wife so that she could commit suicide. That was seen to be contrary to the morals of society. You find that there are acts which are contrary to public policy or morals of society. Certain infringements upon bodily integrity are rendered unlawful, or rather they are rendered lawful by consent. Consider boxing as a sport. It is a very violent sport, but it is still justified. How about a tooth extraction by a dentist? Honestly, if somebody were to meet you in the street and use a hammer to take out your teeth, you would open a case of assault against them. But a doctor does that. That's a dentist. He uses all his tools to extract teeth out of people's mouths and so on. And there are other issues like consent to chastisement by an employer. It actually was considered in the case of McCoy in 1953 in Southern Rhodesia. That is the court of Southern Rhodesia, now Zimbabwe. An employee had actually offered, he actually consented to being chastised, beaten by the employer as a disciplinary measure and for her to keep the job. But the court considered that to be contrary to the morals of society, particularly because the employee was a woman who was being chastised and it was seen to be inappropriate. So there are certain indecent acts performed with the consent of the victim, if one would say, which are rendered lawful. So consent does operate in certain circumstances, but we need to be very careful to observe what kind of circumstances those are. And so ask ourselves the question, what are the requirements for valid consent? It must be voluntarily given. We've discussed the issue of McCoy, Southern Rhodesia, where we said the woman had given consent out of maybe fear of losing a job, and so out of that convenience, that balance of convenience, she offered to be chastised, to be beaten up by the employer. So under such circumstances, it is doubtful if that kind of consent was given voluntarily. And then it must be based on true knowledge of the facts. In other words, the person consenting must be adequately informed of exactly what is taking place. What is it that he or she is consenting to? And then you find that the person consenting must have the legal capacity to consent. You can't expect a child to consent to some of these things. We spoke about a 16-year-old or somebody younger than 16 being drawn into some of these relationships which are exploitative in nature. So to protect children, particularly the girl child, it is very important to remind us that a person consenting must have the legal capacity to consent. Again, we have spoken about minors and children. There are persons who are mentally ill. They can't consent to anything legally, though they may, but the law doesn't, attribute any legal validity to their consent. What about those who are drunk, the drunks, and those who are asleep? If somebody is asleep and you come and ask for a favor and you make them do something, you can't then claim they have consented. They were not they were asleep, they couldn't consent. And then in the case of children, we are saying they are legally incapable of consenting to any or to some of these acts. So they would then require maybe the assistance of their parents and guardians in order to consent, say, to a medical operation. A parent has to sign on their behalf to authorize a medical doctor to carry out an operation or to even extract a tooth. Number 4, we are saying a submission to authority is not consent. In other words, a child consenting to parental authority and chastisement doesn't give a legally valid consent. You can't chastise your child, beat him up, and then you turn around and say they consented to it. You're just submitting to authority, and that's not consent. And so we are saying consent may be given expressly or tacitly. Somebody may make very clear statements that they are consenting to whatever is being suggested, or sometimes they may tacitly be seen to be acting, in line with what has been suggested without resisting it. So under such circumstances would say it has been tacitly given. And then consent must be given prior to the fact, otherwise ex post facto rectification is not valid. In other words, you don't first of all take somebody through, maybe make them do something, then afterwards you turn around and seek their consent. So consent must be given before, not as a ratification of what has already happened. That's very, very important to take note of. So if the purported what called consent is given after the event has taken place, then it is not valid consent. And we are saying consent must be given by the complainant or by a parent or a legal guardian, somebody who has got the legal capacity to give such consent. Otherwise, it's not valid. We have got many other grounds of justification. Some of the grounds include the right of chastisement, that is the right of parents and teachers to beat up the children. They used to have those rights, to punish children within reasonable and moderate circumstances. So they would give reasonable, moderate corporal punishment to children. It used to be accepted. Even some prisoners were subjected to a cane. It used to be a competent sentence in terms of the Criminal Procedure Act until the advent of the new dispensation in 1994. How about husbands? Husbands do not have a right to chastise their wives. Some used to do it in the past, but it's now in the abyss of the yesteryears. And employers do not have a right to chastise their employees either. So that's very important to take note of. And then obedience to orders. One can only take obedience or make obedience to lawful orders. In other words, only obedience to lawful orders is valid. If you are working or you have a boss or supervisor who gives you orders to do something that's contrary to the law, it's not a valid order, and it does not exclude unlawfulness. So obedience to manifestly illegal orders does not avail a valid defense. It is very, very important to take note of that. And then official capacity may also come in as a ground of justification. Take the example of a clerk of court who possesses drugs as an exhibit for court proceedings, or consider police officers destroying liquor from an illicit trade. When that officer does it, he acts lawfully. Or bodily searches carried out by security personnel at the airport. Police, those searches are actually permissible. Or when police officers grab suspects for purposes of effecting arrest. In terms of Section 49 of the Criminal Procedure Act 51 of 1977, it's even permissible for it's tolerable for the police under certain circumstances when effecting an arrest and somebody is resisting or maybe even attacking the police. It is lawful for them to kill that person. And then there is what we call spontaneous agency, or negotiarum gestio, whereby one manages the affairs of another person without their consent or authority. For instance, a doctor who gratuitously carries out emergency operation to save the life of an unconscious patient. Such a doctor acts in spontaneous agency, and that's very, very important. At the end of the day, the doctor has not been appointed, but nevertheless still acts in the interest of the patient, who may lose their life if there is no emergency response. Maybe just out of just to clarify issues, we spoke about boxing as a very violent sport, as you can see over there on that picture. Those people are having sport is actually considered lawful. So those punches on the face, rough and aggressive as they might seem, they are actually deemed lawful because they are being done within the context of sports. And then the right of chastisement or parental, discipline on the children. Look at that person that has cuffs by her wrist. Probably a teacher is actually supervising that child in that manner. And we have just said that that is no longer permissible in law, particularly in South African law. Thank you very much for having been part of today's discussion. Now we come to the conclusion. This video has looked at the unlawfulness as one of the key elements of criminal liability. And we said that unlawfulness is distinct from culpability. It constitutes the unwritten or the invisible requirements of a crime And we said an act which is provisionally unlawful, as demonstrated in the definitional elements of a crime, may be deemed lawful on the basis of certain justificatory grounds. And we are saying there are several grounds of justification and legal convictions of society which may exclude unlawfulness of a provisionally unlawful act. Thank you very much for being part of this presentation. My name is Dr. Philani L Ndlovu, and I look forward to meeting you in other videos. Please remember to subscribe to my channel, to share the videos with others. Let's meet in our other videos next time. Thank you. Bye.